Pierce, are you pro se in this case? Mr. Pierce, are you pro se without an attorney in this case?
I don't claim any legalese terms, including pro se. I'm here defending myself. It's that simple.
Sir, do you have an attorney or not?
I've not been allowed to have assistance of counsel since this started 14 months ago.
We're going to go over what rights you have then today, and then we'll discuss whether if you're going to retain an attorney or not.
Is that what we're going to do?
Mr. Murphy, I note that you noticed a Faretta hearing in Mr. Pierce's case, and you noticed it for 1:30. Mr. Murphy, can you hear me?
Sorry, Judge.
I note that in Mr. Pierce's case, you noticed a motion for a Faretta hearing. And I noted in the court file that it was set at 1:30. Did you want to do that this morning?
That's totally fine with me.
Mr. Pierce, were you aware that you had a motion set at 1:30 today, sir?
No, not at all. None of this has been in CaseNet. They are not communicating with me at all. In fact, there's a motion in the record from several months ago about the prosecutor's office completely refusing to communicate with me at all during the entire time of this proceeding. Yeah.
My simple question to you was, were you aware that you had a 1:30 motion? That's all I want to hear is a response.
No, because it's not on
Thank you.
CaseNet.
I got your response.
Great. Will the prosecutor be punished for
Don't say another word in my courtroom until you're directed to.
Oh.
Do we have any other matters? Gentlemen, do you have pleas or do you have any matters?
Just memos, Judge. Just memos, Judge.
I'll take your memos when you're ready.
Record, please.
Thank you. Yes. Thank you, sir. still show 905s on Rule and Weber. Okay, great. We'll handle those. And then when we are done with the docket, then I want to handle the motion docket, Mr. Murphy.
Okay.
Come on up, sir.
Cheryl?
Yeah.
Well, let's get this finished. Chris.
Sir, come on up.
All right. So, yeah, we'll get you taken care of. What's your last name?
David.
Well, thank you.
Trying to see what your intro was. You've never heard of your
Sorry, I'm in trouble. Did you? No. That's not your guy. The reschedule was building, I was here.
Mr. Murphy, are you okay with doing a plea on Mario Mims? He was ordered to appear today. You doing a plea on February 5th?
That's fine with me, Judge. I just asked that he's ordered to appear again.
Okay, sir. We'll do a plea at that time. Have a good day. Thank you, Chris.
Thank you.
Thank you. Okay. Thank you.
Judge, on line 62, Commissioner Perez,
Yes.
Mr. Malachi told me he has filed the ones that I sent him, so there's probably in the queue, it sounded like he had just
Hello, sir. What is your last name? Thank you. Mr. Rule, my name is Judge Vincent Johnson. I'm going to be handling your bond hearing today following your initial appearance. Sir, you are charged in this case with not paying child support. Your charges emanate from 3 non-support charges which were filed, which each of them were Class A misdemeanors. Your case is approximately a year old. You were picked up, I believe, on bond or on a warrant, and this is your opportunity to have a bond hearing in front of me. The prosecutor is present, sir. You have the right to remain silent. You don't have to say anything to me today. You also have a right to an attorney if you can't afford an attorney. An attorney can be appointed for you if you financially qualify. In order to financially qualify, you would have to submit an application to the Public Defender's Office. Do you understand the charges and your rights, sir? Okay, very good. Sir, do you intend to hire an attorney in your case? Okay. All right. I'm going to ask the prosecutor what her position is on your bond. Your bond is a $2,000 bond. It's a cash-only bond. So I'm going to ask for her position on that. Go ahead, ma'am. Sir, do you have the ability to post a $2,000 bond in this case? Your position. He says I think he's $700. What's your last name? Myers. Right, Ms. Myers, do you have a position on whether to let him out or not? Or recog? I know that this has been a problem with your office. I know that he has not appeared in the past.
More than I like.
Mr. Rule, I'm going to file the direction of the prosecuting attorney, and I'm going to amend your bond to where your bond is $5,000 with 10% authorized. It'll be a cash-only bond. Sir, if you meet that bond, then you will be discharged and get a date. If not, we'll see you on January 8th, 2026 for your next hearing, sir. If you desire to hire a public defender, you will see Judge Childress on January 8th. $500, sir. Okay. I wish you luck. Hopefully you can get out for the holidays, and if not, we'll see you on January 8th, okay? Thank you. Thank you. Do you need a copy?
Like, is there an issue?
Yeah, he's confused on where the corporate rights was.
Okay. Oh, you get that.
This one is done, and you got one day to serve, and that's it. Every 60 days, then you have to.
Come on, sir.
You don't accidentally go out and steal something. Let's not say that. I will get it. Yeah.
I didn't want the old one, the new one.
Come on up, Mr. Schneider. How are you, sir? Good. Mr. Schneider, will you agree to waive your rights in this case pursuant to the cyber rights bill? You understand that among the rights, you're waiving your right to proceed to trial in this case, and that after today, we can't have a trial to determine whether you're innocent or guilty. So show that your waiver rights was completely Sir, as to the charge of careless and imprudent driving, class D misdemeanor, sir, I'm going to accept your plea. We're going to put you on probation for 2 years. I'm going to note that the conditions of your probation are that you need to complete your offender program within 6 months. We'll do a bench probation on this. Your attorney will direct you how you can get to the traffic offender program, finish and prove sent to the court. You'll also have court costs that will be sent to you by separate memo. You want to make sure when you go next door with your attorney that we have your correct address, because that's what the process is. All right, sir, so the only thing you can do really to get in trouble over your probation period is to do something that would result in a criminal charge. You don't look like a common criminal to me. So I don't think you're going to have any problem with probation. Talk to your attorney if you have any questions. All right? Thank you. Have a good day. Thank you. Ms. Falduti. Okay, so first thing, you're agreeing to waive your right to have an attorney present today and waive your right to have an attorney provide you advice on whether you should enter into this plea or not, right? Okay. And accept your waiver of counsel. Well, we haven't discussed your plea yet. All we're talking about is whether you're waiving your right to have an attorney today. Okay? Then we're going to do your plea. Okay? So, as to your plea, you agreed to waive your rights in this case, including your rights to go to trial, correct? Is that correct? Okay. You understand that we won't have a trial in the future to determine whether you're innocent or guilty?
Yes.
Okay. And as to the charge of stealing a Class A misdemeanor, how do you plead, ma'am? I'm sorry? Yeah, you plead, so you plead guilty, correct? Okay. And I'm going to accept your plea of guilty. I'm going to sentence you to 60 days incarceration, commencing on October 20th, 2025. That means that you'll receive any credit for jail time served. And I think you'll be done in 2 days on this case. In this case, will be
Actually, I think tomorrow, Judge.
tomorrow, and in this case, will be formally resolved. Okay? Ma'am, do you fully understand what happened today? All right, very good. I'm going to give you this paperwork. You go back. I wish you luck on your other cases. And have a nice day. Thank you. All right. Having all matters looks like pretty much done. We've got a bunch of our cases that I don't have announcements from.
We're waiting on one incarcerated.
We're waiting on one incarcerated, Mr.
Weber.
Kenneth Weber. what I'd like to do is to wait for him to get Mr. Weber before we start motions, because I don't want to interrupt motions.
Okay.
Hopefully, he's going to get Mr. Weber very soon. I'm sure he is. And then we can proceed forth on any motions. Ms. Myers, on your next case, $50,000 bond, what's your feeling of the bond on that case?
Incredibly similar to the last one, except that it was 17 cases. This is his third time in custody. He's previously posted
All right, then I'll likely do the same. Okay, great. All right, so we'll get done. Thank you. Mr. Murphy, have you heard anything about any of the remaining cases? Alea, Quinteo, Alberto, which is line 3. There's something in the queue on line 25, which is Dargo Valley. That's an Larry Eckelkamp. I show it Attorney Nicholas Lowski. Gary Getman, which is Michael Carter. Scott Hernandez, Frederick Hart.
He's here. Nothing on 3 or 25, Judge.
Okay. Patricia Lilligren, Attorney Dana Altieri. It's line 54. And you said Perez is being resolved, correct?
Right. The plea motion.
We don't see it in the queue.
I just felt that maybe it's just that should be resolved by plea. 54 now.
Mike, can you reach out to
Doing it right now.
guard and figure out how much time he's going to need on that? Do you have something, sir?
Yeah, just the motion to withdraw first, we did last week.
Come on. All right, thank you.
I think line 3 was a no-show last week.
That'll be more. And we'll do our hearings. Mr. Murphy, are you ready on Mr. Pierce's case?
Unless you're going ahead, Judge. Don't worry about
Mr. Pierce, you you can come up and have a seat here. Sir, you can have a seat.
I would prefer to stand here.
Okay, so, Mr. Murphy, what I'm going to do is go over the procedure on this case, make sure that I have everything correct. Mr. Pierce, I'm going to do the same thing so that you have everything correct. Mr. Pierce, before I commence, I've noted in going through the court file that you have appeared numerous times in court and you do not have an attorney, and you did not have an attorney appointed for you. So, sir, do you intend to obtain an attorney in your case? So this is a simple question. It's a yes or no.
So it's safe for me to speak?
Don't be a smart aleck with me, sir. When I address you, you will address me.
I don't know how to deal with the judges accusing me of being a smart aleck and making threats like, don't ever say another room in my courtroom again. I don't know how to deal with you when my safety is threatened. I'm seriously asking, I don't want to go to jail. Is it safe to speak? I'm not playing a game. I don't want to go to jail.
Let's understand how you and I will work in my courtroom. Okay?
Okay.
If I ask you a question, I demand a response.
You demand a response.
I demand a response.
Okay.
If you don't respond to a question that I've asked you, then there can be repercussions for that.
Please state them.
The repercussions are innumerable under Missouri law, sir. Depending on your conduct in my courtroom, you could be held in direct contempt for failing to abide to a court order or held in direct contempt for your general attitude. We demand a quorum in my courtroom. This isn't a presentation. This isn't you doing what you want to do in my courtroom. I will demand a quorum. You will respect me. You will respect everyone in this courtroom. And if you don't, sir, then yes, you can be held in criminal contempt. Let me explain to you what criminal contempt means. Criminal contempt means that I would advise you of the reason why I'm holding you in criminal contempt. At that time, I would offer you the opportunity to purge your contempt. At that time, if you don't, sir, then I would possibly send you to jail. I can do that for up to 1 year, sir, while this case is pending. I don't want to do that. I want to be civil with you. I want you to be civil with me. We have a common goal in this case. You have a goal that you don't want these charges filed against you. I have a goal that I want these charges to reach a resolution. You understand?
Sir, I don't understand what you just said, no.
Very well.
I'm being honest.
And that's why we're going to go to our next thing.
I don't want to go to any threats. I'll say whatever I need to say to not go to jail or be threatened by you further. Just let me know what to say so I don't get threatened. That's the only game I'm trying to play, is not be threatened.
We're not playing the game. And then here's how it's going to go. I'm going to ask you questions and you're going to say yes or no. Okay? So here's how it goes. Do you intend to hire a private attorney in this case, yes or no?
If the truth is neither yes or no, how should I respond?
It's a yes or no question, sir. Yes, I'm going to hire a private attorney, or no, I'm not going to hire a private attorney.
Could the answer be I don't know?
No, because you've had a year to decide what you want to do in this case.
There's reasons for this, sir, and I'm afraid to say them to you or you'll throw me in jail.
No, I'm not going to throw you in jail if you feel, here's what we're going to do today. We're going to make a record on you being offered the right to represent yourself or offered the right to have an attorney in your case, sir. You, up to this point, had participated in court proceedings for a year without an attorney. The court intends to either have an attorney appointed for you, the court intends for you to hire an attorney, or the court intends for you to represent yourself in the future. I need a choice today as to which option you're going to choose.
I'm afraid to answer or I'll be thrown in jail. I don't know how to answer and not be thrown in jail.
Well, if you answer in a respectful way and you respond to my question, sir, you won't be thrown in jail.
I would like this hearing to be recorded so people can hear that I'm being respectful.
Okay. Sir, I don't record hearings unless it's mandatory by Missouri law. In this case, it's not mandatory, so I'm not going to record it.
I just ordered 3 recordings from my hearings with Judge Sancourt for $25 each.
I'm not Judge Sancourt, sir. I'm Judge Johnson.
Oh, I see. So there is no recording going to be made here of this hearing.
Not unless I dictate that a recording
I see.
is necessary.
I would like to just go home with my freedom. I don't want to be here and be threatened by a judge to go to jail if I don't answer yes or no to questions.
Sir, I didn't commit the purported charges in this case. You did. Okay? You're charged with a misdemeanor in the state of Missouri. Okay? You have the right to remain silent. You don't have to say anything to me. We're trying to get you an attorney. I'm trying to help you. So you're going to either state that I want an attorney, I want a continuance so that I can hire an attorney, and I'll give you a brief continuance, or we're going to have a hearing where you're going to waive your right in the future to go forward in this case without having an attorney. Those are your options today.
You said I had a right to remain silent,
You do.
but you said if I don't answer yes or no that I'll go to jail.
No, I didn't say that you were going to go to jail. What I said is that if I find that you are in violation of a criminal contempt, in my courtroom today, I've explained the procedure of what I will do with you.
I don't dare say anything that would risk angering you whatsoever because you have this power of contempt, which means throw me in jail.
Sir, any judge has a power of contempt. If you do not comply with courtroom decorum, and if you don't comply with courtroom procedures, I am again going to ask you whether you are going to hire an attorney, whether you're going to apply for a public defender, or whether you are going to represent yourself in the future, sir. Your answer will be one of those. You can answer now.
Because of the threat of jail, I choose to exercise the right you say I have to remain silent. And I'll
Very
take it
well,
up. Okay.
So I'm going to show number one. This is the first thing that I have asked you to do today that you have refused to do. I'm going to make a record, sir. Refuse to respond to attorney question. Okay. So, sir, by refusing to respond to a question of whether you're going to hire an attorney, or whether you're going to apply for a public defender, or whether you're going to represent yourself in this case, we're going to have what's called a Faretta hearing.
Right now?
Right now.
You're going to expect me, someone who has been denied the assistance of counsel for 14 months by Judge Sancourt, who was just involuntarily recused by the presiding judge of this courthouse for corruption, you're going to force me to participate in a Faretta hearing, which I don't even know what that is, today, right now. You're going to expect me to participate in this today, right now.
Sir, it was noticed up. We're going to have a Faretta hearing. Yes.
Noticed of. I'm not here to argue. I'm just here to let you know a federal team of lawyers is looking to create a federal case against this county, and I'm just here to record what you do.
Sir,
So do whatever you want to do, Judge. I'm just here to
that's
record.
another case, sir. Are
Okay.
you recording?
No.
Okay. Because it's unlawful.
I understand.
Okay, sir.
I
So
would throw in jail.
We have noticed up a Faretta hearing. We're going to have one. Okay, if you think that's funny, sir, I'm sorry, but I intend to comply with the law. The law requires me, if you're not going to either retain an attorney, apply for a public defender, or represent yourself willingly, the law requires me to have what's called a Faretta hearing. I'm going to do that.
Do I have
Sir,
the...
we can do it with you standing up, or we can do it with you sitting down. What would you like to do?
I would like to do a standing up by hand. Do I have the right to assistance of counsel?
No, not unless,
okay.
not unless you've hired an attorney, or if you told me you need an attorney, sir.
So by definition, a right doesn't mean that the state has to pay for it?
Sir, you have a right to represent yourself, or you have a right to self-appointed counsel in the event that you have applied for a public defender. You have not applied for a public defender. I've given you the opportunity to, and you still don't want to either apply for a public defender, get an attorney, or be represented on your own behalf.
Sir, I would like to leave here with my freedom. I'm going to take it up with motions filed to the presiding judge and file a complaint against your conduct here today, this hearing.
Perfect, sir.
Okay.
You can, first of all, you can't leave with your freedom. We're going to have a hearing.
I'm being detained now?
We're going to have a hearing.
Am I being detained?
If you refuse to have a hearing, you're going to be retained. Yeah, detained.
Do I have an obligation to have it? Because I've just declined to have a Faretta hearing. I don't want to refuse. Do I have an obligation?
We're going to have a Faretta hearing. It's known as stuff. We're going to have it on the record, and we're going to have it today.
I noticed that you're not answering any of the clarifications I have for the cause and nature of the charges and proceedings against me here
But I
today.
don't have to.
Okay, clear. You don't have to give a right to the cause and nature of the charges and proceedings. I understand now. Okay.
So, sir, once again, we're going to have a Faretta hearing. We're going to do it right now.
I would not like to participate voluntarily. I'm here under duress and coercion and threat of violence against me. I just don't want to participate in it. I want to take it up with another judge, please.
Your request is hereby denied. So, again, sir, I'm going to ask you, do you want to be comfortable and sit down during these proceedings? I would encourage you to sit down.
I choose to stand.
Very well, it will be long. We're going to go on the record now for a Faretta hearing.
So we are recording this now, sir? Are we recording it if it's on the record? I don't know what to take by the judge's silence.
I don't have to speak a word to you, sir.
I'm not implying the judge has to speak. I'm simply seeking clarification on the cause and nature of this hearing, whether it's being recorded or not, so I have transparency if the judge is violating the judge rules.
When you are ready, clerk, let me know when we're on the record.
May I seek clarification on the risk of contempt? I simply would like a fair warning before being thrown in jail. If I say anything accidentally that would cause you to be angry enough to throw me in jail, I would just like a fair warning and a chance to stop talking so I don't go to jail. Is that agreed upon?
It's agreed upon that you should stop talking right now.
Okay. There are 5 bailiffs in the room right now.
Very well. We're on the record in 2411-CR03275, State versus Joseph Brandon Pierce. This case comes before the court for a Faretta hearing. I'm Judge Vincent Johnson. I preside over the hearing today. Today's 12/18/25. It is 11:19 a.m. I'm going to go over procedurally what has transpired in this case before it being transferred to me. First of all, as to the charges, the defendant has been charged with the offense of animal abuse. The defendant has a right to trial on the charge, and further, the defendant has a right to a trial by jury. The maximum possible sentence on the charge is imprisonment in jail for up to 1 year, and a fine for up to $2,000 or both imprisonment and a fine. That the minimum possible sentence if the defendant is found guilty by judge or jury is 1 day imprisonment in jail and or a fine in the amount of $1 or both by such confinement and fine. The defendant is aware that any recommendations made by a prosecuting attorney or other prosecuting official are not binding on the judge, and that any recommendations may or may not be accepted by the judge. The defendant pleads guilty. If the defendant pleads guilty in this case or is found guilty of the charge, the judge is most likely to impose a sentence of confinement in this case if found guilty after a judge or jury trial. The defendant is here today. He's Joseph Pierce. He refuses to sit at counsel table, so he is standing. The defendant has been afforded the opportunity to represent himself or retain counsel in this case. The defendant has also been advised that he has the ability to request and fill out an application for a public defender. The defendant has refused to inform the court if he's representing himself. The defendant has informed the court that at this time he is unrepresented by an attorney, and the defendant has refused to inform the court whether he will hire an attorney in this case or remain unrepresented to go forward. The court notes that the defendant has not made any claim of being indigent and unable to employ an attorney. And if the court found that the defendant was indigent and incapable of hiring an attorney, the defendant would be entitled to a public defender. So in that case, we are going to move forward with a Faretta hearing. So the purpose of the Faretta hearing, Mr. Pierce, is to advise you under oath that you have certain rights in this case, sir. These rights include the right to represent yourself, the right to have an attorney appointed for you, and Mr. Pierce, the right for you to hire local counsel to represent you. Sir, as to those three matters, the right to represent yourself, the right to apply for a public defender, and or the right to retain an attorney, what is your intention before the court today, sir?
I respectfully decline to participate in this hearing because right before it happened, the judge has threatened me with jail if I speak in a way that upsets him.
Okay. The court will note and take record that the defendant asked the judge what would constitute criminal contempt in this case. And the court went through a litany of examples. The court also demanded the defendant have decorum within the courtroom and demanded that the defendant be respectful. The court will be respectful to the defendant and anybody else that is in front of the court. Again, sir, for the last time, I'm going to ask you on the record, before we do a Faretta hearing, whether you are going to represent yourself, whether you're going to apply for a public defender, or whether you will obtain a local attorney to represent you in this case. Once more, I'm pleading for you to provide one of those three responses. Sir, what is your response, Mr. Pierce?
I'm scared. I'm trying to think of what I can say to not go to jail. Can I still remain silent, have the right to remain silent like you said I had earlier?
Sir, you have the unequivocal right to remain silent. What we're going to do is we're going to go through the elements of a Faretta hearing today, and then at the end, sir, if you have not waived your right to an attorney, the court will note that it's read and advised you of the risks and perils of proceeding without an attorney, but the court will continue in this case and set this case for jury trial.
At no point in time do I desire to waive any rights.
Perfect. We will continue.
We will continue while I am under duress, under coercion, and scared to speak to defend myself. Just to be clear on the record what is happening, there are 5 bailiffs in this room, and I stand here alone without the assistance of counsel for 14 months straight now in this case.
And that is at your own peril, sir. You have not obtained an attorney. You've appeared at numerous hearings. You haven't brought an attorney with you. You haven't applied for a public defender. And you haven't advised anyone that you intend to hire an attorney in this case. The court will now make a record of what has happened so far in this case. Information was filed on 10/16/2024, alleging the defendant committed the crime of animal abuse. The defendant was arraigned on 2/3/25. The defendant refused to enter into a plea, including a plea of not guilty. So the court granted the defendant the benefit of entering a plea of not guilty at that time. The defendant posted a subsequent bond of $2,500 on 2/6/25. On 3/10/25, pursuant to the defendant's request, the defendant was granted a change of judge, which case was reassigned from Judge Burns to Judge Sancourt. On 6/26/25, a request for disclosure was filed by the prosecuting attorney in this case. On the same date, the PA sent 17 items of evidence that they had in their file and may intend to use at a trial proceeding. The defendant has received these, or purportedly received these, from the prosecutor's office. On 7/7, let's back up the bus. On April 2nd, 2025, a hearing was held in front of Judge Sancourt, wherein the defendant requested for WebEx to act as his attorney. This was denied. The case was continued until 5/28/25. On 5/28/25, Mr. Pierce, you appeared again without an attorney, and the court set your case for a bench trial or plea on 7/16/25. Prior to 7/16/25, you were provided with 17 items of evidence by the prosecuting attorney's office. On 7/7/25, you filed numerous motions: a motion to vacate a plea, a motion to dismiss, a motion to strike. These were all subsequently denied by Judge Sancourt. On 7/11, the prosecuting attorney's office filed additional discovery letter wherein it disclosed 2 more additional items of evidence, one being a video of the log and the other being purported pictures and or evidence of a gunshot. On 7/15, sir, Mr. Pierce, you filed a motion to dismiss, a motion for public records requests from the city of Winsville. These requests included public records, jail surveillance, and audio records from the city of Winsville. On 7/16, you again appeared at court by yourself and without an attorney, and the case was continued to 8/27/25 for counsel status. You apparently asked for a jury trial at this time, and the case was continued for counsel status. On this date, 7/16/25, the state filed additional disclosure of evidence, being 26 pages of dog-related expenses, 2 pages of a summary report, and these were provided to you. On 8/25, you filed a motion to compel disclosure of exculpatory evidence. On 8/27, you appeared again in this court without an attorney, and this court set for this matter for a pretrial conference on 10/15/25, and also advised you to get an attorney. It was set for counsel status. On 9/30/25, the court set this matter for a jury trial to commence on November 19th, 2025, and gave you the opportunity to appear at 2 pretrial conferences, these being on 10/15/25 and 11/12/25. On the pretrial conference of October 15th, 2025, all of your motions were denied, and the case was set on jury for jury trial on 11/19/2025, and you were again advised to get an attorney. On 10/25/2025, the state filed a motion for a Faretta hearing and noticed it on 4/11/12/2025 at 9 a.m. The state also filed a motion to continue the trial setting and set this for 11/12/2025 at 9 a.m. On 10/27/2025, the state disclosed additional evidence of 911 calls, and these were provided to you. On 11/12/2025, you appeared again in court without an attorney, And the court granted the state's continuance and reset this case for a jury trial on March 28, 2026, and set this matter for a pretrial conference on January 7, 2026. You filed a motion to document, a motion to have ChatGPT as your co-counsel or attorney of record. The court states that the motion that you filed on 10/15, which appears to be something for some type of a disclosure, would be heard on 12/3/2025. This motion appears to be a document called Notice of Issues to be raised at pretrial motions hearing. On 11/13, you made a record request for recordings of prior court hearings. On 11/21, Judge Sancourt recused himself and the case was reassigned to me. On 12/2/2025, the prosecuting attorney noticed up a Faretta hearing which shall be heard today. On December 16, 2025, the defendant filed a motion to enter YouTube videos, filed a motion for return of bond, and a motion to dismiss. This brings us to the Faretta hearing, which is heard today. Sir, I'm going to go over the waiver of counsel form at this time. Sir, we have a pre-printed form in the 11th Judicial
May I speak at all?
Yeah.
Okay.
Sir, we have a pre-printed form as to the waiver of counsel form that the 11th Judicial Circuit uses. Have you reviewed it, sir?
Sir, I don't know how.
Sir, have you reviewed this form?
Reviewed what? I'm sorry?
The waiver of counsel form, sir. Have you reviewed it?
I didn't even know such a form existed.
Perfect. We're going to hand it to you. Please hand it a copy of the waiver of counsel.
I've already said I don't want to waive any rights.
Sir, at this time, we're going to go through the waiver of counsel form word by word.
I don't have a choice. I'm being detained. Let's do it.
At the top of the waiver counsel form, it describes that this is the 11th Judicial Circuit of St. Charles County, Missouri. I'm Judge Vincent Johnson. Your case number has previously been announced. If you execute this form, we will fill in this case number and your name. This form requires you to review it and understand it. So we're going to review everything of record, and you're going to select whether you're going to execute this form or you're going to deny to execute this form.
Will I be able to use my right to remain silent?
First of all, sir, this form says the following. I request that the court allow my waiver of attorney with full understanding that I'm entitled to an attorney if I so desire, and with full knowledge and understanding of the following additional considerations. Instructions for defendant. You would initial by each consideration that you show you understand the statement. I've previously informed you that you were charged with animal abuse. This is a Class A misdemeanor in the state of Missouri. The range of punishment in a Class A misdemeanor is up to 1 year in jail and or up to a $2,000 fine. The minimum payment or minimum consequences for this offense is a 1-day period in jail and or a $1 fine. Those would be in the event that you are found guilty and a judge or jury sentences you the same. Sir, item number 2 says that you have the right to be represented by an attorney, and that if you're indigent and unable to employ an attorney, you have the right to request a judge to appoint an attorney to assist you in defending you against the charges. And then the court will appoint an attorney to assist me if it finds that I am indigent and not able to employ one. As to that, sir, are you claiming that you are indigent today? Hearing no response, the court will note that the defense of indigency has not been made. Sir, are you requesting the court to appoint you an attorney to assist you in defending against these charges?
I'm not allowed to speak in my defense, and I'm
Sir,
being
I'm asking you a question. Do you intend to have a judge appoint you an attorney to assist you in defending against your charges?
I exercise the right you said I had to remain silent because I'm too afraid to speak in this courtroom with this judge, and I'm going to take it up with another one.
Sir, this is a simple question. Do you intend to ask me to appoint an attorney for you?
You said I had the right to remain silent. I
Yes or no, sir?
exercise the right to remain silent.
Perfect. I'll note that despite repeated requests, the defendant refuses to have the judge appoint an attorney to dismiss or to assist him against these charges.
Does it have to be a public defendant?
Sir, you have a right to a trial by a judge or jury. You have previously requested a jury trial. Is that correct, sir?
I only said that if they were not going to dismiss the charges and continue to impose upon me, absent any factual evidence of jurisdiction whatsoever, that I would choose that over a bench because the judges have been so corrupt against me that Sancourt just got recused involuntarily for corruption, and I know every judge in this building will rule against me because they're all in favor of the
Sir, this is
prosecutors.
a simple question, and we're not going to listen to theatric responses. Sir, do you have the right to a judge trial or a jury trial? You have requested a jury trial. Is that what you still want?
Well, I'd like to challenge jurisdiction if it's allowed without me going to prison.
Sir, simple question again, and this is your last opportunity to respond. Are you still requesting a jury trial, sir? Yes or no?
Yes.
Thank you.
Because
You have the right to remain silent. You don't have to make a statement which can be used against you in the prosecution of the criminal charges that are filed against you. Do you understand that?
I'm under duress. Any answer I give is null and void because of the threat of violence against me here today.
Perfect. Sir, you also have you're aware that any recommendation made by the prosecutor is not binding on a judge. But if the prosecutor made a recommendation to resolve this case, you would have the opportunity to either accept or reject such a recommendation. You understand that, sir?
Any statement I make is under duress because of the threat of prison that judge is making against me here today. I'm too fearful to answer.
Mr. Prosecutor, have you made an offer to resolve this case to the defendant?
I have not made a formal recommendation, but it would be jail time, sir.
Do you want to make a formal recommendation of jail time at this time?
I decline to hear the prosecutor's offer.
120 days jail.
Sir, Mr. Pierce, the prosecution has offered you a recommendation in exchange for a guilty plea. He would recommend that you serve incarceration of 120 days in the St. Charles County jail. Do you wish to accept that recommendation?
What plea is on the record right now? There's no plea entered on the record right now.
Again, sir, we're going to have a simple question and answer session.
Okay.
Do you intend, yes or no, to accept the prosecutor's recommendation, or in exchange of guilty, you will serve 120 days incarceration?
I decline that.
That will be declined for the record. Thank you. Please note that if you enter a guilty plea, or if you are found guilty by a trial on the charge, the judge is most likely, in this case, to impose a sentence of confinement of jail or prison. Do you understand that?
Again, any answer I give is under threat of duress, under duress and coercion.
Okay. I will note that you failed to respond to that.
I did.
Also, that after a judge or jury would make a finding in your case of innocent or guilty, you have a right to appeal the court's judgment and the jury's verdict, and/or the jury's verdict, should you exercise your right to a trial in this case and be found guilty. Do you understand that?
I don't understand that. I failed to understand that, what you just said. Can you
Okay,
repeat
well, I'm going
it?
to go through it again.
Great.
You have a right to appeal the court's judgment or the jury's verdict should you exercise your right to a trial and be found guilty at trial. Do you understand that?
I understand that Missouri has a law that says if a dog is on your property and trespasses, you can't be charged criminally.
We're not going to talk about the case in this case, the facts about the case.
There's a Missouri.
I'm warning you, sir.
Oh, okay.
I'm warning you.
Okay.
I'm putting this as number 2 on the things that I have warned you about your conduct today, sir.
I don't dare speak
I
anymore.
have told you that you will not discuss the facts about this case.
Okay.
In addition to being disrespectful to the court and not responding to the question of whether you will hire an attorney or waive your right, sir, I'm noting now that you have refused to continue to listen, that you will not interject any facts concerning this case at this time, sir. By doing so, sir, you are putting your case into jeopardy, and you are not preserving potential rights that you have to remain silent, sir. So, sir, those are for the two issues. We're going to keep going. Sir, I want you to be advised that you have the capacity at this time to make an intelligent decision and knowledge of your situation. This decision involves that you can either waive your right to an attorney or hire an attorney. This is very simple. You seem like an intelligent person. Have you received education, sir? Did you graduate from high school?
Out of fear for my freedom, I decline to answer any questions posed to me during this hearing and this judge.
Very well.
Okay.
It seems to the court, and seems that because you filed elaborate pleadings in this case, that you are an educated man, and therefore you understand and can make an intelligent decision on whether you will be waiving your right to an attorney and representing yourself in this case.
I do not waive any rights.
Sir, you claim that you are acting under duress. Sir, there is no duress. You simply have the right to an attorney. This involves you acknowledging that I'm going to represent myself, or I'm going to have an attorney help me out in this case. You have done neither. I show, sir, that at this point you don't seem to suffer from a mental incapacity or incapacity. Sir, is there any mental illness or defect that the court should be aware of regarding you?
I have no mental defects whatsoever.
Perfect. I show that you are literate, and that you're minimally familiar with the trial process. Sir, are you familiar with how the case will be handled if the case goes to trial?
I've been threatened with jail. If I defend myself here in this hearing, I will refuse to speak and assert my right to remain silent. Sorry.
Very well, sir. And I'll explain the trial process.
Okay.
At trial, sir, you have the right to present whatever evidence that you desire to present on your own behalf. The procedure of a trial will be that the state will present their evidence first. You will have the opportunity to cross-examine any evidence and/or witnesses that they would bring forth in their trial. The state would then rest. You would have the opportunity to bring forth whatever witnesses and/or evidence that you would desire in your own defense at trial. At the end, in this case, since you've requested a jury trial, a jury of your peers will decide your fate. As you are aware, that jury could come back with a not guilty decision and you would be released. The jury could also come back with a guilty decision, and then you would be subject to the minimum and maximum fine and jail time amounts that I have advised you, sir. Sir, you have the right to represent yourself in this case. You seem familiar with the court processes. You also seem familiar with any possible defenses that you may be able to bring forward. You filed documents in this case on your own behalf, and the court notes those. The court will make sure that you understand that the possible penalties in this case, if you're convicted, are up to 1 year in jail and up to a $1,000 fine. You will also understand that the pitfalls and dangers associated with waiving any rights today, including constitutional rights. Sir, I want to advise you in general, if you decide to go to trial on your own behalf without an attorney, you will be going up against a team of prosecutors who have went to law school. You also, sir?
Yes, sir.
Were you being disrespectful to me by making gestures in my courtroom?
No. No.
Don't do it
I would never
again.
do such a thing. I won't do it again.
Don't do it again,
Okay.
sir. That's number 3, sir.
Okay.
I'll remind you, sir, at this time, if you at any time in my courtroom make a mockery of the judicial system or make a mockery of my courtroom, you will be held in contempt. Do you understand, sir?
I'm doing my best to be expressionless.
Sir, I am going to ask you a question again.
Yes, I understand.
Thank you. The court having found that you have not claimed to be indigent in this case, I will note that you have the right to counsel, that you are absolutely refusing to invoke your right to counsel today. And I'm advising you that this is a mistake to proceed without a lawyer in this case.
I would like the right to assist. May I have assistance of counsel, please? The right to assistance of counsel in the Bill of Rights is what I would like to take advantage of. Please, if you'll allow it.
Sir, are you asking to apply for a public defender in this case?
I could not have been more clear what I just asked for. It was from the Bill of Rights, the assistance
Sir,
of
I
counsel.
don't have to respond to any request from you.
Of course.
Okay? I am asking you whether you are seeking to have an attorney represent you. This whole day has been a waste of time if you are going to have an attorney represent you, sir.
I have a question about that. May I ask and not be threatened with jail?
Depends on what you say, sir.
Okay. I'll be very careful then. For all the previous 14 months of this case with Sancourt, I had the same question I asked the 6 lawyers I called. The 6 lawyers closest to this courthouse, I have called and attempted to retain them. And they all say, if I'm not allowed to record audio, it's because the judges hate me and are against me, and they're not going to take the case. I tell this to Sancourt, he says he doesn't care, he still can't record. So all of these judges that the lawyers, the defense lawyers that are local here that I could retain, are all afraid of taking me on as a client because of the abuses of power that the judges have documented against me in these hearings. So there's problem number 1. Problem number 2 is, I'm wondering, and I brought this up with Sancourt, who again has been recused involuntarily for corruption. Am I able to get a lawyer who is not, quote unquote, representing me in full? Can he be just assistant, like a sidebar, whatever? And the reason why that would be appealing to me is because when I file these motions that are with the assistance of my actual assistance of counsel, which is LLM models like ChatGPT, and it has been this whole time whether the court recognizes it or not. My question is, if I file these motions, then they'll have this signature of, let's say, a public defender on it. Therefore, all of these motions that I file won't be categorically ignored until they finally get to a motions hearing that I have to fight for 6 months, and then they're all categorically denied with no grounds given whatsoever in favor of the prosecution side. Meanwhile, the court records all of these things happening as facts that are absolute lies, do not happen, and I could prove if they would just look at the record, but because I'm not allowed to speak, I'm not allowed to bring this up, along with the fact that Missouri law states that no one can be charged with a crime civilly or criminally for shooting or killing or harming a dog on their property when there's a threat of imminent harm. It is in the rule books. I don't know what I'm doing here.
This is a simple question. And we're at the end of the Faretta hearing.
Okay.
Sir, you, as of this point, do not have an attorney, and you are going to be representing yourself in this case. I have advised you every pitfall. I'm going to continue to advise you what the pitfalls are. Sir, before you made the gestures and turned around and turned your back to me and made some cartoonish...
It was toward the prosecutor, not you, sir.
Yeah, you'll demand a quorum, or I demand a quorum to the prosecutor as well, sir. So you won't have any tomfoolery in my court. You understand?
Agreed.
Okay. Sir, I'm going to also go into where I was at before you interrupted, and that is that in this case, sir, you're going up against a team of prosecutors. The prosecutors have went to law school. The prosecutors understand the rules of evidence. The prosecutors understand the Supreme Court rules that will apply in this case. Sir, you do not have any of that education. So, sir, but understand that I will hold you to the same standard that I'm holding to them. Meaning you will have to comply with the rules of evidence in this case. You will have to comply with the Supreme Court rules that are administered by the Supreme Court and duly published. I anticipate if this case goes to trial, you may be at a disadvantage. So I implore you to hire an attorney to represent you. So that being the case, or that being the end of the Faretta hearing, I'm going to conclude this matter by setting your case for jury trial, which is what you requested. Sir, I will note that you have on the record had a Faretta hearing. I will note that you have refused to acknowledge that you are waiving your right to be represented by an attorney, and you have refused to inform the court whether you are hiring an attorney. So, sir, I've met my burden of going through everything I need to in this case. What we're going to do now is we're going to set your case for trial, and then I'm going to set your case for a pre-trial.
I categorically deny everything the judge just said as being untrue and provably untrue on the record, respectfully. I just don't agree with it, that's all.
Very well, we can go off the record. Thank you. I'm going to set this, Mr. Prosecutor. I would like to get to this case very quickly. Are you prepared to have a jury trial on this on February 17th?
Yes, Judge.
Very well. You're number 2. There is a case in front of us that
I think that should be resolved, Judge.
you are also the prosecutor on. Sir, I'm going to set this case, Mr. Pierce, for jury trial. I did implore you to get an attorney. The case will be set for jury trial on February 17th.
I request the right to assistance of counsel. It means the state has to pay for it. I'm not paying for it. The state has to pay for it, and I don't want you to be, quote unquote, representing me. I just want a signature on the document so this system can stop ignoring it. You just ignore me because I'm not a bar member. With a bar member's signature on it.
I haven't addressed you, have I?
I would just...
Sir, have I addressed you?
No?
You'll remain silent. The case will be set for a jury trial. Mr. Prosecutor, how long do you think that you will need to try this case?
Maximum 2 days.
Mr. Pierce, how long do you think that you will need to try your case?
2 weeks.
Very well. The court will set this case for a 3-day jury trial. We will summons 75 jurors for the panel. How many we hold in here? 60.
That's more than just jury max.
So, 74? Okay, we'll summon 74 for the jury panel. I'm going to set this case for a pre-trial hearing. I don't know why we had 2 pre-trial hearings set in the past, but we won't have 2. We're going to have 1. Pre-trial hearing on this case will be set for February 5th.
If you're asking a question, Judge, I have an answer to that question.
I'm not asking a question. Pre-trial hearing will be at 1:30 p.m.
Judge, I'm sorry, what date did you say?
February 5th.
Thank you.
Trial will commence at 9 a.m. on February 17th. This will be a jury trial. Of 3 days. So, Mr. Prosecutor, you will be filing jury instructions in this case. I will want them lodged and filed before the pre-trial conference.
When do my jury instructions get filed, sir?
Copies will be given to the defendant in this case. Mr. Pierce, if you have any requests, changes, or any issues regarding the jury instructions, we will have a pre-trial hearing and they can be brought up in pre-trial. Mr. Prosecutor, if you would have jury instructions prepared and sent to the defendant no later than February 2nd.
I'll have my jury instructions sent to the prosecutor by then as well.
Mr. Pierce, typically the defendant doesn't prepare jury instructions, but this is an additional incident where you are acknowledging that you're familiar with the court process and intelligent to proceed in this case.
Thank you.
So, sir, we'll look at anything that you file, but traditionally the prosecution file jury instructions, and typically they are simplistic in nature.
Yeah, I just want to be on the same level playing field as the prosecutor side, so I'll file my own instructions. They can read those as well, like during notification and whatnot.
Very well. Okay, do we have anything further? We do. We have a motion that I note that I have read. The court previously treated this as a motion. And this was a document called Notice of Issues to be Raised at Pretrial Motions Hearing. To the extent that that is a motion, it will be noticed up for hearing on February 5th, along with any pending motions. The court will note that prior to today, every motion that has been filed in this case has been denied. The only pending motion that will continue on this case is the purported notice of issues to be raised at pretrial motions hearing. They'll be heard on February 5th, and any subsequent motions that are filed in this case. Mr. Pierce, since you have now elected to represent yourself henceforward in this case, sir, you will have the same burden as the prosecution.
I do not agree to represent myself in this case. I seek the assistance of counsel as in the Bill of Rights, the assistance of counsel. I'd like that right, please.
Sir, you have not claimed that you're indigent. And if you did claim that you were indigent, I would give you an appropriate hearing in front of a public defender. You've denied to do that. You've denied to apply for a public defender. So, sir, that's your option. You have the option. You told me that you have reached out to 5 attorneys and in an attempt to hire them, sir. So it appears you have the ability to hire attorneys.
It was to prove a point, sir, not to hire them.
And, sir, this court will not be appointing you an attorney. Okay? You'll be representing yourself.
Well,
and I'll explain the perils of doing so.
I still seek the right to assistance of counsel. It doesn't say anything about indigent in the Bill of Rights, so I'm still seeking that.
Okay.
Yep.
Do we have any further issues, Mr. Murphy?
I have one question. I just need a kind of piece of this.
Very well. All right.
What is it?
This is the 911 call. I just want to make sure you know this.
Bailiff, you
Now,
can give it to
of who? Who's 911 call?
It's your 911 call.
I already have this. I'm seeking the 911 calls of the dog's owner. Those are the ones that have the exculpatory evidence that shows collusion and a conspiracy to charge me when there was no ball in this dog's mouth that attacked me.
We're not going to have
Court.
any hearings today.
I already have this.
regarding Any unnoticed motions.
So I'm seeking, they're breaking the Missouri Sunshine Law by not giving you the 911 call from the dog's owner.
Again, we're not going to discuss the case. We're not going to discuss anything that is not noticed up properly in a motion.
It's exculpatory evidence.
I don't care what evidence it is, sir.
Just-
It will be held in a pretrial hearing.
Just wanted that on the record that you don't care that it's exculpatory. Okay.
Well, sir, we're not on the record.
Okay.
So, but you can state whatever.
Okay.
Sir, I wish you a good holidays, and we'll see you.
Can I bring up anything?
On February 5th. Mr. Murphy, do you have anything further?
Just that we note on record that I handed them a piece of discovery today and 911 calls. So we can write that on what happened or if I need to.
Mr. Murphy, I noticed that you filed you filed 3 different disclosures of evidence in this case.
Yes.
Your first disclosure contains 17 documents and/or recordings. Sir, you subsequently then filed an additional disclosure containing 26 pages of dog-related expenses and 2 pages of a summary report. And sir, you recently, on 10/27, made the additional disclosure of 911 calls. And sir, is the disc that you gave him that your 3rd disclosure?
So the disclosure, the last one you just mentioned, that is the same 911 call. I believe we had his address incorrect. That's why I wanted to hand him the physical copy here.
Very good.
I already have it from his office, from him. I already have a copy of it.
That's okay, I'm glad you have it.
When he doesn't know what he's
Okay, so
doing.
we will conclude the hearing. Thank you for everyone for your participation.
May I?
Mr. Pierce, I would encourage you to hire an attorney as soon as possible. You will proceed in this case without an attorney. I will not continue this case at all, period, for any reason whatsoever.
Are American citizens allowed to challenge the jurisdiction of American courts?
Sir, I wish you a good Christmas, and I hope you have a good holiday. We'll see you next year.